Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations related to steno and steno dictations. Get ready for the high speed passage. Learned counsel appearing for the respondent understandably supported the finding of the Labour Court in regard to the evidentiary value of the receipt produced by the management store. He further contended that the High Court was justified in enhancing the back wages to 100% since the material produced by the appellant for the first time in the writ court showing that the respondent workman was gainfully employed could not have been accepted in evidence or relied upon for denying the workman his legitimate right to claim full back wages. Stop. He also submitted the said evidence was not reliable and, in fact, the workman was not gainfully employed. Stop. Stanza. Having heard the learned counsel for the parties and having perused the records, we notice that the factum that the workman was in the service of the management till 22nd of April 1993 is not disputed. Stop. While the workman contends that his services from that day were wrongfully terminated, the appellant contends that the workman voluntarily left the services of the appellant having taken all his dues. Stop. Since the respondent workman was in the service of the appellant management at least up to the 22nd of the April 1993, the burden of proving that he voluntarily left the services then falls on appellant management. Stop. This is satisfied by the oral evidence adduced by the management and the documentary evidence produced in the form of the receipt purportedly executed by the workman and the entries in the bonus register. Stop. The Labour Court, considering the said document, which is said to be a receipt executed by the respondent, noticed the fact that the original of this document was never produced by the appellant and what was produced was only a photocopy. Stop. Even this photocopy was not confronted to the workman when he was in the witness box, and the signature found in the said photocopy, as also in the photocopy of the bonus register, shows that though two documents came into existence simultaneously, the ink with which the respondent workman is supposed to have signed the two documents was different. Stop. In such circumstances, it held that it was not safe to rely upon the said document to accept the case of the appellant. Stop. The High Court in this regard held though it may not be necessary to apply the strict rule of evidence in regard to production and proof of a document, still the workman ought to have been provided with an opportunity to explain his version as to the alleged receipt having been executed by him, and such opportunity not having been offered by confronting the document to the workman, the appellant in effect has violated the principles of natural justice, and hence by its act of default the workman's case cannot be prejudiced. Stop. However, as stated above, Shri Lalit Learned Senior Counsel contended that the workman was aware of the contents of the document because he had the photocopy of the document served on him, based on which he had cross-examined the management witness. Stop. Stanza. He further contended that since the workman had been unable to establish through his cross-examination of the management witness that the receipt in question was not executed by him, it should be held that the document in question stands proved, and the case of the management as to the voluntarily abandonment of service by the respondent after taking all his dues is also established. Stop. We are unable to accept this argument because if we look into the overall proceedings before the Labour Court, we notice that though the management did take the stand that the workman had left the services of the appellant management voluntarily by receiving his total dues in full and final settlement. It did not, at the stage of filing of its return statement, contended that the workman has executed a receipt which is now sought to be produced as Exhibit 1 stop. This, coupled with the fact that the said document was not confronted to the respondent workman, in our opinion, is sufficient to hold that this document cannot be relied upon for establishing the fact that the management has proved its case. Stop stanza. Challenge in this appeal is the judgment of the learned single judge of the Patna High Court holding that the appellants were not entitled to a decree for specific performance of contract. Stop. In a second appeal filed by the respondent, the judgment and decree of the trial court, as affirmed by the first appellate court, were reversed and the suit of the plaintiff was dismissed. Stop. Originally, the suit was filed by the husband of the appellant number 1. Stop. After death of appellant number 1, his legal heirs were substituted. Stop. The High Court proceeded on the basis that the plaintiff had not proved that he was ready and willing to perform his part of the contract. Stop. There was neither pleading nor evidence was tendered in terms of requirement of section of the contract. Stop. There was neither pleading nor evidence was tendered in terms of requirement of section 16 within bracket C of the Specific Relief Act 1963. Stop. Learned counsel for the appellants highlighted as to how the judgment of the High Court suffers from various infirmities both factually and on principle of law. Stop. None appears for the respondent, though she was represented by a counsel who did not appear on several dates of hearing and also is not present today. Stop stanza. The High Court recorded findings to the effect that there was no specific averments in the pleadings that the plaintiff was ready and willing to perform his part of the contract, and also no evidence was adduced in this regard. Stop. As rightly pointed out by learned counsel for the appellants, the findings are contrary to the materials on record. Stop. As noted by the first appellate court in various paragraphs of the plaint, more particularly paragraphs 18 and 22, specific averments regarding readiness and willingness of the plaintiff to perform his part of the contract have been made. Stop. Additionally, the plaintiff, who was examined as PW9, has categorically stated that he had gone to tender the money, that is the consideration, to the defendant who was not agreeable to return the sale deeds, and therefore the only course left open to the plaintiff was to file a suit. Stop stanza. On this ground alone, the judgment of the High Court is vulnerable. Stop. Another factor which appears to have weighed with the High Court is that even though 1 month time was granted by the trial court to the plaintiff to deposit a sum of rupees 1500, this was not done. Stop. This again is a finding contrary to the materials on record. Stop. There can be no quarrel with the proposition that in a suit for specific performance of the contract, the plaintiff must prove that he was ready and willing to perform his part of the contract continuously between the date of the contract and the date of hearing of the suit. Stop. But the finding that the plaintiff has not proved his capacity to perform his part of the contract, as he was not even ready to deposit the money in terms of the trial court's order, is factually wrong. Stop. It appears that no such plea was raised by the defendant before the first appellate court. Stop.